Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're doing commentary on the case.
Is that correct?
Dati mihi Anglican point, service Latina.
That's literally not true.
I didn't ask you to interrupt me. Oh, for crumb's sake.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. There we go. I have to find myself there. Hope you guys had a great lunch. I'm sorry I was just a tiny bit late because, in all actuality, some new gear arrived and I got a little distracted. So I've got some extra cables plugged in right here while I'm trying to test it out. And, of course, it's not set up yet, but soon. All right. I figured out the problem. I just need I need to have 2 DHCP servers on a single network. That's all I need. It's just a simple ask. Yeah. All right, we're back. Joe Sherlock, you missed the answer? You left us early. Man, we had the full verdict. So the new piece of equipment is that little one right here, this little tiny box right on top. Not this part, but this part. It is a 4K streaming decoder. It's like a decoder ring you used to get back in the day in a Cracker Jack cereal box, but it works on the internet. That's the best way I can explain it. It's a streaming decoder. MSN member for 38 months. OG, thank you very much. You have only one DCHP server. I have at least 3. My problem is they're conflicting with each other, and so I want to have 2 networks live together in peace. Please put chat on the screen. Greeners, there we go. Chat is on the screen. And Regina Adams, congratulations. You were first in chat today. We're going to honor you with this little one-off saying, and at the same time, we're also going to punish you. And everything IP related worldwide is your responsibility. Good riddance and congratulations. Good luck. Weebug, member for 24 months. OG, thank you very much. I did not ask you to throw any scat at the screen. Right. We've almost got to that, but no, we're not there. Let's see. Right after the trial closed, Judge Peeler ruled. Tia was found not guilty of burglary and assault. Wilson was found not guilty of burglary, but got a guilty verdict on the ag assault with the deadly stabby. Yes, that's how it went down. DSN gifted 5 memberships to kick off the lunch hour. Thank you very much for your generosity. We have we're trying to find some courts to watch that will maybe end with a little more satisfaction than what we got in this Ohio Warren County Court. So maybe we'll jump down to 7 first and see what's happening up in Thurston County, Washington.
On the side, the camera over the side entrance to Mr. Rainey's home, where there was originally the concern about private recording of private conversations without consent.
Civil stuff.
Mr. Rainey indicated that camera no longer has that audio feature. There was evidence of that occurring one time. There's not evidence of a pattern of behavior, a course of conduct where Mr. Musgrave's private conversations are being recorded. And so given that and given the testimony from Mr. Rainey that audio feature has been turned off, I'm not finding grounds for an anti-harassment order on that front as well. We've addressed the trespassing and the property damage and the property line disputes as well as not relevant for anti-harassment orders. Mr. Musgrave has asked about, is he able to take pictures of Mr. Rainey's property as evidence that his privacy is being violated.
Can I violate his privacy because mine is?
There's an order in place, and I know there's a question about the current order and the restraint provisions in the current order where Mr. Rainey is the protected party. and Mr. Musgrave is the respondent, there are 3 restraint provisions, and they say, number 1, there's no cameras recording petitioner's backyard or pointed at petitioner's windows. Number 2, no cameras on petitioner's side, so Mr. Rainey's side of the fence. Number 3, no pictures placed by Mr. Musgrave on Mr. Rainey's side of the boundary fence. So this seems to be a question about cameras recording Mr. Rainey's backyard or pointed at Mr. Rainey's window. Mr. Musgrave, if you feel that you're seeing evidence that your privacy is being violated by cameras pointed at your window, I'm not going to say you can't take that picture. The language of the anti-harassment order in place prohibits the recording of Mr. Rainey's backyard or cameras pointed at Mr. Rainey's windows. And I think in context too, it was recording cameras is what we were talking about.
Right. Yeah,
but at the same time, you got to be careful though, because there is this order here in place, and if you're.
Oh, we just lost it. That's weird. Not sure why. Thurston's all done playing nicely. Let's see if we can jump over here to a different court. Let's see.
There is this order here in place, and if you're doing things like taking pictures of the windows at Mr. Rainey's home, and it turns out to be a toy box or something like that, that's you want to be careful about that. You really you're going to want to have a little more solid evidence that your backyard is being recorded before taking pictures and doing things like that, and coming back to court. Okay, so I want to caution you.
I had picked up a heat source there. It looked like there was a camera lens. I realize now that it's probably the part of the box.
Okay, but Mr. Musgrave,
he's using a thermal
also
camera?
Be careful, because you're talking about you've got a device picking up heat sources, right, at Mr. Rainey's home.
That was a few weeks ago.
Right, and so I remind you that there's this order in place saying you're not allowed to be recording or having cameras pointed at Mr. Rainey's windows or backyards. And so to the extent you have devices that are picking up heat signatures, right? I mean, you got to be careful about that.
It was my phone.
Okay.
It was just an app on the phone that does that. And so I checked one time to see, and I think I put in one thing that I saw 2 or 3 heat sources there.
There's no app on a phone with a thermal.
Well, okay.
And there's other ways to find cameras with their infrared or their blue light, night vision stuff.
He's got them all.
That's why I'm asking is, if there are still cameras over there, and I want to prove there are still cameras pointing at my backyard.
Can I use cameras?
Am I allowed to do that?
Yes, you are, but you can't. I'm not going to give you legal advice, right? But you've heard what the petition against you says.
Right.
Should we go back and get?
You have a reasonable. This whole thing started with allegations of infringement on a reasonable expectation.
We're going to go back. We're going to go back.
And I would also caution you on if you don't need to collect.
Thurston's going to deliver. Thurston's going to deliver on this one. I can tell.
So since I'm going to be careful to not keep going back and forth. So I think the last word before I make.
We'll finish this ruling.
Contact provision. It sounds like the parties do not live near each other. And
40 minutes.
So I do think that because the nature of the relationship.
Back about 40 minutes. I was close. Here we go. Let's go right here. This is the beginning. Okay, thank you, Josh, for the buffer there. Appreciate you doing the homework. We have to hear the full scoop about all the surveillance that's going on between these two neighbors. Give the judge a minute to get the previous order all signed and out of the way, and call the next case. All right, Judge, we're ready when you are. By the way, that's a nice time.
All right, and final case of the day here.
Thurston County civil stuff is the best, absolute best.
Cause number 26-117, David Musgrave versus Adam Rainey. We got Mr. Musgrave here in court, Mr. Rainey on Zoom. Good morning to you both. Come on up, Mr. Musgrave.
These are neighbors.
All right,
no tree issue that I know of.
From that prior case. All right. So I know folks have been here before. Same parties have been here with
they're familiar.
Positions switched. And a lot of the allegations here are sort of grounded in similar allegations. So I think we're all familiar enough with the allegations here and the responses. So rather than go over an overview here, I think what I'm going to do is give each side sort of just essentially a bit of a time limit to kind of summarize your allegations or the response. And then I'll make a decision here rather than kind of go piece by piece. I know Mr. Musgrave, you've outlined a couple of different buckets of allegations here. And so rather than me kind of go through those point by point, I'll give you some time to talk and can let me know which ones you'd like to focus on.
Sure.
All right. So it's 10:40. I think what we'll do is we'll give each side 5 minutes. And if I have some follow-up questions, we can have this be a little bit more dynamic. But again, I don't have any specific questions. I think it makes a little more sense to have folks just provide some testimony. So Mr. Musgrave, can you please raise your right hand? Do you swear or affirm the testimony you're about to provide is the truth and the whole truth? All right, go ahead.
Okay. I'm not sure.
And you also don't have to take up the full, if you want to just say, I rest on what I've filed, that's okay.
Well, you probably read through all of this.
I have read, it looks like everything through April 20, so last Thursday. Okay. I know there's looks like exhibits were uploaded, and so I've read everything through that.
And a lot of these are from the previous one. So, okay. So my issues, I think I stated the problems. What I'm requesting is that, the main things that the cameras are that are aimed at our backyard are removed, that the recordings of our private conversations are stopped and deleted, and that Adam and his family are served notice of trespass from our property. I also wanted to address the photo of the camera in the window. There was a heat signature there. I don't know how an empty box would have that. And the
using the thermal camera.
yeah, and
so good.
And that being a protection order violation of the photo. I don't know if you saw Adams reported it to the police that was a violation of the protection order. I understood we were talking video cameras recording, which have all been taken care of, not a photo of evidence, which is what I considered that. If I had thought that was part of the order, well, I'm not stupid, I wouldn't have done that. But I didn't consider a photo the same as the video recordings. And as you can see also in this, I have addressed those cameras. They are now moved, covered, so there are no video cameras in my backyard that are recording anything of Adam's house.
So I do actually have a question since it sounds like you raised it. So you have alleged there are cameras aimed at your backyard. And I know that Mr. Rainey there has essentially responded that the camera referenced you took a picture of one of the windows at Mr. Rainey's home.
And it was an empty box.
And saying that was I think a Funko box. were there other cameras?
I saw 3 different heat signatures, and I didn't photograph the other ones because they were on the first floor. But that one, they would not have been able to see what I was doing the week before in my backyard from those other cameras, but they would have been able to see it from a camera on the second floor, which was why I pointed that one out in particular. Yeah, anyway.
All right. And if you'd like to, I mean, you summarized everything rather well. I think maybe, if you'd like to just kind of rest on your summary of everything, I can turn it over to Mr. Rainey to talk about his response. And if I have follow-up questions too, then maybe I can start asking questions that way.
Okay. But yeah. Like I said, if you read through it, I'm fairly comfortable with what I.
All right, I did read through that. So, okay, Mr. Rainey, what we'll do is we'll put you under oath. So if you could please raise your hand. Do you swear or affirm the testimony you're about to provide in this matter is the truth and the whole truth?
Yes, Your Honor.
All right. And yes, Mr. Rainey, for your benefit, I did review, looks like you filed a 6-page response on April 23rd, and I did read that. And so I did see the response with respect to that alleged camera maybe being a Funko box. I'm curious if you want to talk a little bit more about the Ring camera. I mean, I'll sort of be upfront. One reason why I granted the hearing was I know that the order in which Mr. Rainey is the protected party was grounded on privacy in the backyard. And so allegations that Mr. Musgrave made about similar violations of his privacy on filming in his backyard and into windows into his home, and then the private conversations being recorded, that more than anything else really formed the basis of my granting a hearing. Mr. Rainey, you've sort of addressed each of those directly in your responses. So those are the things that I was also concerned about, that I really set the hearing to address. And so I know that you're saying the camera, the alleged camera facing his backyard is that Funko box, and that you've provided as well some exhibits showing that the Ring camera on the side of your home that I think Mr. Musgrave was saying films into his window, and that may have been the camera that picked up the conversation that was brought up in the prior hearing when you were the petitioner, that those have been moved, or that they're no longer being used, or that the audio has been turned off, things like that. If you want to speak to those issues too.
Yeah, correctly. I'm sorry.
No, go ahead. Those were the things. Any cameras facing his backyard, cameras facing in his windows, and anything that picked up audio in an area where someone has a reasonable expectation of privacy. You've addressed those in your exhibits. Those were also top of mind for me. So if you want to direct your comments there, that's.
Yeah, certainly. Yeah, the box that's my daughter's window. It's just the empty toy box. We don't have any cameras in our backyard at all. And as far as the Ring camera, Mr. Musgrave at our last hearing said that it was offline already because he noticed the lights. So it's been off since then and non-functional. As a courtesy, we understand his concern, and we turned it off. It was off that day. As far as seeing his backyard, we put a fence up so he doesn't have to see in our backyard any longer, so we don't have to see him. And we knew the fence, we put it up because he said he was going to do maintenance at our last hearing. So we just preemptively put the fence up in case he wanted to take the fence down, since we depend on it for our pets. There's no contact from us from his side. He has 30 cameras facing our house. Not one time has he reported anyone trespassing. So all these allegations are just untrue.
All right. So I think what I'm going to do is run through
Judge,
my notes on the different claims here, and kind of let folks hear where I'm at. So number one, again, primary reason that I found grounds to set the hearing is allegations of cameras on Mr. Rainey's property facing into Mr. Musgrave's backyard, that those need to be removed. I'm hearing that there's two ways that Mr. Musgrave is substantiating those claims. Number one is viewing what was believed to be a camera that having reviewed the photo myself, not just the one blown up by Mr. Rainey, but the photo that was included in Mr. Musgrave's petition. I agree, at least to me, if you really look at it, and I have Funko boxes myself at home, and it does appear to be a Funko box. Now, Mr. Musgrave is saying that the cameras he has show heat signatures around that area, as well as that Mr. Rainey or his family know about where he may have been at certain times, and sort of that being circumstantial evidence that he's being recorded. Frankly, I don't know if that meets the preponderance of the evidence standard, that it's more likely than not that forms the basis of me being able to conclude that Mr. Rainey has cameras pointed at your backyard. So at this point, I don't think that there's anything in the exhibits or in the evidence that I can look to say, all right, there are cameras that by court order Mr. Rainey needs to remove. The issue that I was concerned about when the petition was filed was that camera on the side of the house, because I do recall from the first hearing that there was a camera on Mr. Rainey's side of his house that did pick up that private conversation from Mr. Rainey. I know, Mr. Musgrave, you've also inquired in the exhibits, kind of what do we do with that? And I think that was addressed at that prior hearing. The remedy by law in that case is the content of what is recorded without consent is not admissible as evidence against someone in a civil hearing, and it was excluded in that last hearing. I didn't consider that, and
it's excluded from evidence.
So you had asked in this petition, you had asked what was the remedy of that of your conversation being recorded, right, without your consent. And what I was saying is, well, the remedy occurred at that last hearing, which is under the statute that says you're not allowed to record someone without their consent. It says the consequence of that is if that evidence is attempted to be used against the person who was recorded, then that evidence is suppressed and not used.
What's that statute?
And so at that last hearing, I did not consider that as evidence against you.
In that particular hearing.
Yes. And so
is it still a crime?
Well, and that's where, you're welcome to call police if you think a crime is being committed. I'm not going to make any kind of conclusion about something being a crime or not being a crime. And it sounds like Mr. Rainey, in response, has provided evidence that camera is no longer
But it could be turned right back on.
Sure. But in order for the court to issue some kind of order in an anti-harassment protection order, there needs to be a knowing and willful course of conduct that's persisting. And from my view of the evidence is that you've discovered that a camera on Mr. Rainey's property had picked up a conversation as part of that prior hearing. We addressed it, and it sounds like at this point that camera was then turned off and not recording anymore. And so, you're saying, well, what if he turns it back on? The court's going to need evidence of an ongoing pattern of behavior of you being recorded, your conversations being recorded, in order for the court to have grounds to take any action against.
But even if that camera is turned on, it doesn't have to necessarily record me to be looking into.
Right. Well, and it sounds like though that camera's off.
For now, that's why I'd asked that it be moved someplace where it can't be looking directly into our house.
Yeah, and so I'm not going to sort of prospectively order cameras that aren't currently being alleged to have violated someone's privacy.
I had to move mine.
Right, because those cameras were on, right, and they were pointed at.
But they were the view of his property was blocked by the camera. Those cameras have the one that they were concerned about has the ability to block that part of its view.
Right. Well, in my understanding, Mr. Rainey, is that the camera on the side of the house, is that, was that moved? I can't remember. Now I don't recall from your.
The camera on the side of the home.
Go ahead, Mr. Rainey.
The camera on the side of the home is disabled. It's deleted, and the battery is removed. It's non-functional.
Yeah. Yeah. All right. And so, and the other thing with that one, with that camera in particular, is, my concern there was primarily around the audio recording, and because when it comes to where people can put their Ring cameras to capture video versus audio, it is a little bit different, because that's why people have Ring cameras, right? They film the sidewalk, they film someone's front door, they film the driveway. You do not have a reasonable expectation of privacy in places where you're already sort of out in public. If being familiar with these properties, the camera is filmed, or the camera was pointed at the end over the side door entrance to Mr. Rainey's home, that did capture a portion of Mr. Musgrave's home, but this is also an unfenced side yard that
it is fenced.
That pictures.
It's completely fenced. It had a gate. It had a fenced gate as well. In fact, that's one of the things I recently included, was so you could see that there was a gate and there was a fence that was there. But
the camera at issue, right, is I'm looking at the picture of the two homes now, and the camera at issue is over the side entrance to Mr. Rainey's home that is exposed to the front yard and the street. And is that right?
No, the side door is exposed to the street. It used to be the garage. They added the door off the side of the garage. Their entrance is like 30 feet away around the corner, the entrance to the front of the house. That side door is not used for public entrance.
Okay, right. All. But the side door, this is the camera that you're concerned had picked up the audio from the first case.
And
right?
Looks into our house.
Right. So I'm looking at, now I'm going back to, I think you put the screenshot from the incident where your audio was picked up.
Right.
So I'm looking at the camera, and unless things have changed, what I can see is you talking to your friend. I can see Nova Middle School. I can see the street. I can see the sidewalk. This area is not.
Okay, it's hard to see, but right there in the photo is one of the fence posts.
Right, but but this is what the view looks like. Isn't that right? The view in the camera.
Right, it's looking over the top of the fence. Right.
So the reason I'm bringing this up is, this is an area where a Ring camera can go. The issue isn't for this camera. The issue was picking up audio without consent, right? Because it is part of your house is on the camera,
and it was in a fenced-in area. There was a
right, but I mean more the fence here. It's not exclude. When we're talking about a fence in this context, we're talking about, is this a fence that if you're on the other side of it, it's indicating you have a reasonable expectation of privacy. And here, the area being filmed by the Ring camera is exposed all the way. Again, I'm looking at Nova Middle School. I mean, so it's across the street. You can see into this area. So you being in this area doesn't necessarily give rise to a reasonable expectation of privacy. Now, again, your audio being recorded without your consent is a different issue. And that's the issue that we took up in that first case. And it sounds like Mr. Rainey has disabled that feature as part of this camera. The camera itself, though, as a Ring camera is traditionally used, this is not a place that I think is violating anyone's reasonable expectation of privacy. Because again, it is in an area that is fully exposed to the sidewalk, the street over.
It's like 40 feet from the street.
Yeah, but I find that
80 feet from that school.
But I think that the position of the camera, I think, is not something I'm concerned with as far as a violation of a reasonable expectation of privacy. It was the audio recording for that camera in particular. Going down the line, you've also brought up essentially wanting Mr. Rainey and his family to be served notice of trespassing. And it's the grounds there. So first of all, there's nothing about the anti-harassment process that has a formal relationship with a trespass notice. You as a private property owner are free, and sounds like you have put up no trespassing signs on your property. The way the unlawful harassment process would interact with that is if there is trespassing that then also meets the definitions that we've gone over before, trespassing happening as a ongoing course of conduct for the purpose of harassing that reasonably causes substantial emotional distress. You've alleged that Mr. Rainey's daughters, again, have gone onto your property to retrieve Amazon boxes, and that there's been occasional times when they've walked across your
daughter and son. Yeah, after the no trespassing sign and fence were up, snuck across the front yard.
Yeah,
rather than walk around, come up the driveway, which is what I understand is the proper path to the front door when there's no trespassing signs.
And so there's a difference. There's three types of trespassing here. So there's criminal trespassing, right, where you would, and you have called the police saying, someone is coming onto my property without my permission. And so, if you feel that is happening and someone is criminally trespassing against you because they have notice not to come onto your property and they're doing it anyway, you call the police. That's a criminal matter. There's civil trespassing, where you have to show that this is causing me some kind of damage. And, there you have to actually show, there's this level of damage. For purposes of harassment, again, there needs to be trespassing to a point where it's a knowing and willful course of conduct happening for the purpose of harassing a specific person, and that causes substantial emotional distress.
The incidents I have brought up with the contractors.
Well, and again, we can't just say trespassing for a bunch of different people. We have to stay focused on specific allegations. So you've alleged that Mr. Rainey's daughters are trespassing as grounds for anti-harassment.
Okay.
Yeah.
Well, that's just one. That's like the last incident, but there were
right. But at
least a half a dozen incidents before that where I had to keep telling people to get off of my property.
The daughters in particular?
Huh?
The daughters in particular?
No.
Well, that's why, again,
the Rainey's contractors who kept using my lawn.
So that's the contractors. That's a different issue too. So we'll get to the contractors.
But they were telling them to use my lawn.
Okay, but we're going to stay on the daughters for a second. Okay, because you have to allege trespassing against someone, right? And so you can't say I'm being trespassed against by these people and the contractors.
I had also pointed out the roofing people. That was one of the
that's right.
specific incidents.
So staying on the daughters though, I don't think that there's trespassing by Mr. Rainey's daughters in a way that satisfies the unlawful harassment statute. I don't think there's a pattern of behavior of them coming onto your lawn.
I thought that repeated trespassing,
even if it happens more than once, again, that there needs to be an ongoing course of conduct that rises to the level of causing.
Well, that's why I was mentioning all the contractors that led up to me having to put the fence up and the signs up and the cameras up.
Hang on. The point that you're missing is you need to allege trespassing against specific individuals.
Okay.
Right. And so you're saying you were trespassed because Mr. Rainey's contractors and roofers, a couple of years ago used the part of your property for their work, and then also
will have been ongoing over the last 2.5 years.
So you need to. There needs to be more of a focused allegation, because I can't just say, the world around Mr. Rainey's property that is trespassing against you. There needs to be specific instances that you're tying these allegations to against specific people. Right. And so you've alleged, number one, you've alleged Mr. Rainey's daughters for trespassing against
and the roofers and the paver installers.
All right. So I'm not finding that any of this rises to a level of an ongoing course of conduct, a knowing and willful course of conduct, that there's trespassing happening. Now, if you're against you, now, if you've alleged many times that you think there is property damage on your property from Mr. Rainey's contractors and the roofers, right? And I think you've also acknowledged that that is property damage, and that's if you want to bring a small claims action or any other kind of lawsuit against Mr. Rainey for property damage, that's different than unlawful harassment,
which is planned.
Right. So that's different than unlawful harassment. So
I still don't understand. Like I said, the pavers, the roofers. There was the one photograph that I included that showed all of the different projects that are on that side of the house that he has had contractors stage those projects on my lawn. And I've had to go out there and tell those contractors to move their stuff off of the lawn.
I know, and to the extent that you have alleged that those contractors are coming onto your lawn to stage the work, I'm finding that that's not a knowing and willful course of conduct for the purpose of harassing you that would reasonably cause substantial emotional distress. If he
knew that I told them to stop doing that, and he would still send them over there.
Right. No, I understand. And again, to the extent you have a property damage claim that you would like to litigate, that needs to just be litigated. That's not for unlawful harassment.
I understand that's completely different. I just feel like there has been a pattern of trespassing.
I understand. So, Mr. Rainey, maybe it would be helpful too if you'd like to maybe provide some concluding remarks on, when you've got contractors doing home improvement projects, where you're telling them to go, if you're, having them avoid, coming on to.
We actually do. Anyone that comes to our home to do any kind of work at all, we tell them to avoid that side of the yard because Mr. Musgrave will come out and yell at them and say things to them. So we tell them just avoid that area altogether, and they stay on the other side. I don't know where he's coming up with that. They're walking there constantly. We haven't had any work done in years, and honestly, it's kind of ridiculous. And the only other thing I would like to address is Mr. Musgrave has cameras pointed directly at our driveway 24/7. He claims in his filings, and then he's posting the videos up on YouTube. And I don't understand how that is different than his claim that we're recording him from.
We need his channel. Camera. Where's his channel?
Right. Okay. So I want to stay on the contractors piece of it. So
somebody find the channel.
This year, not years ago.
Right. Well, if I understand,
the thing about roofing is they were very careful. There's a dumpster in the front of the house they were scraping into, but there's wind, things accidentally blow over. It was like one piece that fell on our side of the yard that he threw over. So this allegation that people are throwing stuff on his yard is unfounded and ridiculous, to be honest.
Yeah. So we're gonna put that allegation to rest. So, Mr. Musgrave, I understand you're frustrated. It sounds like in your mind that there's ongoing trespassing on your property from contractors working for Mr. Rainey.
Why the fence and the signs are there?
Right,
and the cameras.
Right, I understand. For purposes of getting an unlawful harassment order, I'm not finding that constitutes a knowing and willful course of conduct that would reasonably cause substantial emotional distress, or that's engaged in for the purpose of harassing. I'd find that that's just not in evidence at this point. Now, again, if you feel your property has been damaged or you think people are criminally trespassing, you have rights to call the police or to file a lawsuit. But at this point, I'm not finding there any grounds for unlawful harassment for what's been alleged there. On the recording piece of it, Mr. Rainey, to address your concern there, it was cameras pointed. Again, this is where we get into where is there a reasonable expectation of privacy, and it can get a gray area. There's a big difference between front yards, driveways, things like that are exposed to the world, and areas that are more private. The issue before was, again, this is why it's a gray area. When you're on the side of the house that is between the two of your homes, that is exposed to the sidewalk. But when it's a private conversation between two people kind of off on the side of the house on their own property, that's a little bit different than somebody out front in a driveway near a sidewalk. So for purposes of what kind of audio gets recorded, I think those are different situations. But again, I think for purposes of where your Ring camera is, as far as it not recording audio on the side of the house that reaches all the way over to Mr. Musgrave's property, that sounds like it's already been addressed, and you're not recording audio over that camera. But to the extent that Mr. Musgrave has cameras pointed at driveways and in the front yard and the sidewalk, that's clearly a public area where there's less of a reasonable expectation of privacy there. There was allegations about landscape trespassing, landscaping being over the property line. Again, there's a lot in the allegations around conflicts in property lines. Again, that's not something we address here at the anti-harassment calendar. Those disputes are litigated in Superior Court. So if folks want to petition for a boundary line adjustment, do a quiet title action, to really verify where the property line is, again, that's a matter for Superior Court. We don't resolve that here.
Both his contractor and I know that you can find the steel pins in the flat.
And that's right. That's contractor's opinions on a property line is not, that's one thing. But if there's a legal dispute over property lines, that needs to be resolved in Superior.
I used a metal detector to find the steel pin at the front, which is one of those things I read is the way to find the property line.
So on balance here, again, the two things that I was primarily concerned with in the petition were if the fenced backyard area Mr. Musgrave's property was being recorded by cameras on Mr. Rainey's property. That was my first concern. I think that has been addressed, and I'm not finding that there's evidence of that occurring by a preponderance of the evidence.
Your Honor.
Yes.
Yep.
Am I able then to photograph the other cameras that I believe are there?
Hang on. We'll get back to that. The second is the camera on the side. The camera over the side entrance to Mr. Rainey's home, where there was originally the concern about private recording of private conversations without consent. Mr. Rainey indicated that camera no longer has that audio feature. There was evidence of that occurring one time. There's not evidence of a pattern of behavior, a course of conduct where Mr. Musgrave's private conversations are being recorded. And so given that, and given the testimony from Mr. Rainey that audio feature has been turned off, I'm not finding grounds for an anti-harassment order on that front as well. We've addressed the trespassing and the property damage and the property line disputes as well as not relevant for anti-harassment orders. Mr. Musgrave has asked about, is he able to take pictures of Mr. Rainey's property as evidence that his privacy is being violated? There's an order in place, and I know there's a question about the current order and the restraint provisions in the current order where Mr. Rainey is the protected party and Mr. Musgrave is the respondent. There are 3 restraint provisions, and they say, number 1, there's no cameras recording petitioner's backyard or pointed at petitioner's windows. Number 2, no cameras on petitioner's side, so Mr. Rainey's side of the fence. Number 3, no pictures placed by Mr. Musgrave on Mr. Rainey's side of the boundary fence. So this seems to be a question about cameras recording Mr. Rainey's backyard or pointed at Mr. Rainey's window. Mr. Musgrave, if you feel that you're seeing evidence that your privacy is being violated by cameras pointed at your window, I'm not going to say you can't take that picture. The language of the anti-harassment order in place prohibits the recording of Mr. Rainey's backyard or cameras pointed at Mr. Rainey's windows. And I think in context too, it was recording cameras is what we were talking about.
Right. Yeah,
but at the same time, you got to be careful though, because there is this order here in place. And, if you're doing things like taking pictures of the windows at Mr. Rainey's home, and it turns out to be a toy box or something like that, you want to be careful about that. You're going to want to have a little more solid evidence that your backyard is being recorded before taking pictures and doing things like that, and coming back to court. Okay, so I want to caution you.
I had picked up a heat source there. It looked like there was a camera lens. I realize now that's probably the part of the box.
Okay, but Mr. Musgrave, also be careful because you're talking about you've got a device picking up heat sources, right, at Mr. Rainey's home.
That was a few weeks ago.
Right, and so I remind you that there's this order in place saying you're not allowed to be recording or having cameras pointed at Mr. Rainey's windows or backyards. And so to the extent you have devices that are picking up heat signatures, right? I mean, you got to be careful about that.
It was my phone.
Okay.
It was just an app on the phone that does that. And so I checked one time to see, and I think I put in one thing that I saw 2 or 3 heat sources there.
Okay.
And there's other ways to find cameras with their infrared or their blue light, night vision stuff. That's why I'm asking is, if there are still cameras over there, and I want to prove there are still cameras pointing at my backyard, am I allowed to do that?
Yes, you are, but you can't. I'm not going to give you legal advice, right? But you've heard what the petition against you says,
right?
If you have a reasonable this whole thing started with allegations of infringement on a reasonable expectation of privacy, right? And so I would also caution you on, if your need to collect evidence of an invasion of your privacy raises to the level of you needing to get night vision goggles and heat sourcing. That's before, right? There were cameras pointed into Mr. Rainey's backyard that were causing emotional distress on the part of Mr. Rainey and his family, right? Part of the anti-harassment order statute, as I went in before, is the behavior alleged needs to cause someone substantial emotional distress, right? And so if you're needing to seek out that type of evidence against you, it also, there's an issue there. Are you feeling a substantial emotional distress because of something happening to you, versus you going out and trying to find something that's going to?
I'm stressed. I'm very stressed. You could talk to my therapist about
I can
that.
tell. So again, I'm not going to give you legal advice, and I'm not going to say what is or is not a violation of the order. What I'm going to say is, if you want more specific questions answered about that, you can always talk to an attorney. And keep in mind that the order in place right now prohibits the recording of Mr. Rainey's backyard or recording, having cameras pointed at Mr. Rainey's windows, given that he has a reasonable expectation of privacy.
And the cameras recording to me meant video. I didn't consider a photo recording. I understand. I have looked up to see whether a photo is considered a recording, and there is references to that in Washington law because it's a record. Mm-hmm. The photo is a record. It's yeah. Okay. But that's not from a layman's term, what I thought we were talking about.
And there's not an allegation against you as part of this hearing. So
right, but there is an allegation against me based on that protection order
that's not being heard today. And again, I don't want to wade too far into those waters because that's not before the court right now.
I'm just trying to be clear about whether
and that's why I'm having this discussion, is because I do want to try to resolve confusion here so that folks aren't coming back to court. And unfortunately, the scenario you're bringing up, I think, has a lot of gray areas. So that's why all I'm going to do is caution you and advise you maybe talk to an attorney before you do things like that. Because
that's what I was asking. I'm not
right, and I can't give you legal advice on complying with the order. All I can do is read you the order and read you, what the unlawful harassment statute is. Mr. Rainey, do you have any questions? I know you've been here during all this.
No, I have no questions. I just want Mr. Musgrave to understand that we do not find him interesting enough to record him, to watch him. We don't have any feeling for him. So all this nonsense about whether to take pictures of my backyard are kind of silly because we don't care to do that and we have no cameras. So, I mean, that's all I have to say about that matter.
All right. Okay. Well, so that will be it for today's hearing. So I'm not going to sign an order. Mr. Musgrave, if you have questions about what kind of conduct may or may not violate the order, I strongly suggest you talk to a lawyer, particularly if you get into this kind of gray area of, using your phone to capture heat signatures and things like that. I'm not going to tell you if that's a violation or not, but I do suggest you talk to a lawyer before doing that.
Who does tell me?
A lawyer.
A lawyer. You're going to have to talk to a lawyer who can give you legal advice.
My wife's an attorney, and I do talk to her, and she says, hang on.
Okay.
But she's like kind of confused by the same bit of the recordings and photo and whether that's what you intended by
the
order.
intent, this is the last thing I'll say, and I'll let folks go. The intent is to not infringe upon the Rainey's reasonable expectation of privacy, right? So that's the whole reason of this whole order and of the statute. Is part of the reason here is there an unreasonable infringement on a petitioner's reasonable expectation of privacy? So maybe it would be helpful to go back and not focus so much on the exact definition of what is a recording versus what is a photo. Think about what is a reasonable expectation of privacy, right? Because that is what the statute is intended to protect. And so, is somebody using their cell phone with an app that reads heat signatures or night vision, but it's not necessarily recording? Does that violate this order? Again, I talk to an attorney. I'm not going to say, and I'm not going to tell you one way or another. I'm not going to give legal advice, but I do suggest that you think about what is the purpose of the order here, which is to protect a reasonable expectation of privacy, and whether or not observing that kind of data would make someone feel like their privacy is being infringed or not. So think about it that way. Again, I'm not going to provide any answers here. Think about it that way. I'm not going to sign an order today.
And what about his camera looking in our house?
We've addressed that.
I understand he's turned it off, but it's not that hard to turn it back on.
Well, again, we've addressed that already. So I'm not signing an order today. You're all free to go. Again, if you have questions about the order that's in place.
I kind of felt like, that's okay. It's there as long as he doesn't turn it back on. But if he turned it back on, then he would be violating a protection order. That's what I was hoping, because it's just that easy. It's like me pointing a camera at his backyard again.
Like I did last time.
Well, none are pointed there right now.
But it's not on right now, right? So what I would need is evidence of ongoing.
Okay, they're done. They just cut the feed. Okay, we're going to jump over to Judge Raquel West, who I think has a jury selection going on. I'm just trying to see, get a feel for what's happening here. This started just a little bit ago. Thurston never lets us down. It's so good. It's so good. I need to see these 30 cameras, though, on the side of the house. Okay, let's zip forward. The attorneys are facing the gallery. This means it looks like jury selection. Let's fast forward just a little bit. See if some people come in. Okay, we're filling up the seats. People are showing up. Almost full. Now what are we waiting for? Just to the judge.
I got a stubby little pencil.
We need Mr. Farag back. Okay, it looks like... Oh, here we go. Judge is here. Oops. One more. All right.
It makes a difference on whether or not we can do our job if you're here or not. And so we really do appreciate you because we cannot do our job without you. The first thing that I'm going to do, and you can all remain seated while I do this, is I'm going to give you an oath. So I'm going to ask if you would all please raise your right hand. Do you and each of you solemnly swear that you will true answers give to all questions propounded to you concerning your qualifications as a juror, so help you God?
You will true answers give.
And so all that means is that you promise to tell us the truth this afternoon. The process that we're going to go through is called voir dire, which just means to speak the truth. And what we will do by the end of today is have a jury selected that will serve for the next few days with us. We don't anticipate the trial this week lasting longer than a few days, and so we just need you to be able to be here for the for this week. Used to, if
strong
you
with this
jury,
one, the force is
panel. Excuse me. Probably pre-COVID. Goodness. Pre-COVID. We used to have you go down to that jury and paneling room downstairs.
Cough while you say COVID.
And then a judge would come down there and
qualify
a big, huge group of you, and then you would get sent to the courtrooms. What we have now with iJury, I think, is a whole lot better because at least you don't have that process that you have to sit through and then get sent to a court. But also what that means is that I need to go through with you what the qualifications are to be a juror.
We're going to skip
and
ahead.
then I'm going to ask all of you if any of you think that any of those qualifications.
Back 50 minutes or so. I'm not sure if we're going to have time to. Let's see what they're doing here. Just looking at the time, it's 3:05. Backing up an hour, we'll be done for the day before we see where they're going.
Okay.
So they've all taken the oath.
Obviously, with the court reporter moving down there, you all know, and those of you who've been through this before, know that she is not just taking down everything that I say or that the lawyers say this afternoon, but everything that you all say also. And so it's going to be very important if you're called on to answer a question that you please speak loudly and clearly so we can all hear you. And also, we'll be calling you by your name, your juror number, so the record can be as clear as possible, kind of who's talking at what time. I understand, and the attorneys understand, that public speaking is not everyone's favorite thing to do. If there is a question that is asked of you that you are not comfortable answering in front of 59 or 60 of your new best friends, all you have to do is say so. At the end of this process, we'll take a break, and I'll have all of you leave the courtroom. And if we need to talk to anybody after, we'll bring you guys in one at a time. So what we don't want is for you to have some information that could affect your ability to be fair in this case and you not tell us. And then we get into the trial and we're a day or two going down the road and you say, I should have said this and you didn't, and it could potentially cause a mistrial. And we would have to do this all over again, and we don't want to have to do that. Everyone has personal experiences. The reason for this process is because everybody has personal experiences that could affect their ability to be fair in any given type of case. Everybody's not set out to be a juror or made out to be a juror on every kind of case. And so that's what the lawyers really want to know. They want to get to know you, get to know how you feel about certain offenses and things like that. And so that we can get as fair a jury as possible. An example I give is that let's assume that you went to dinner last night, and when you came home, your house had been burglarized and ransacked, and precious, irreplaceable items had been stolen. And you show up the next day for jury duty, and it's a burglary of a habitation case. It may be a little soon for you to be fair on that kind of case. You may say, you know what, I feel so victimized that I could never be fair if it were that type of case. Or you may be able to say, you know what, I can put that aside. I can take into consideration just what I'm given here in the courtroom and not let a personal experience influence your determination of guilt or innocence. So it really just depends on you, and that's why we need this chance to talk to you. We talk about this process being jury selection. It's really not a selection process. It's really a deselection process. And the way that works is that the lawyers each at the end of this process, after they've both talked to you, they have 10 strikes that they can use.
10 strikes.
This week is cause number 25, DCCR 1626. It's styled the State of Texas versus Romeo R. Johnson, who's charged by indictment with the offense of unlawful possession of a firearm by a felon. The range of punishment provided by law for this offense is between 2 years and up to 10 years in prison and or a fine of up to $10,000. And so representing the state, we have Mr. Tommy Coleman.
Good afternoon, everyone.
Shout out Tommy.
And then representing the defendant, we have Mr. Marcus Wilkerson. And the defendant, Mr. Romeo Johnson.
Hey.
And so what I'll do is kind of what I did before. I'm going to go row by row and ask by a show of hands if any of you know any of us. And so I'll start here on the first row. Do any of you know any of us? No? All right, second row. Anybody? I mean, first row, second side. Second row, going across. Let's see.
I saw
Is
him
it
there.
Mr.
Right there in the middle behind the guy in black.
Bishop?
Mm-hmm.
No. You're Mr. Bishop? So it's Mr. Bennett.
Mr.
Number
Bennett.
22, Mr. Bennett.
Mr. Bennett.
And who do you know, sir? Okay. Is there anything about that that would make you feel like you couldn't be fair in this case? Okay. Well, we might visit with you about that after.
He said yes.
Anyone else? Second row. Let's see. And sir, are you Mr. Walker?
Yes.
Number 25. And who do you know, sir? You do? All right. So we'll talk to you about that also.
I know the defendant.
After docket.
Oh.
Or after this process. Let's see.
Yeah, he's getting struck. If you know the defendant.
Second row, going further over. Third row. Well, hi there.
Howdy.
How are you, sir?
Doing great.
So we've got, that's number 32. Officer Bowman is in charge of security here at the courthouse, or one of them. And so, Officer Bowman, you obviously know, or Deputy Bowman, you know everyone here, correct?
Yes.
Is there anything about any of us or your relationships with the attorneys or myself that would make you feel like you wouldn't be able to be fair in this case?
No.
Okay. And we may visit with you also in a second.
One of the bailiffs is called on jury duty.
Let's see.
Yeah,
Third row coming back across this way. Coming over here, third row. All right, back row. Anybody? And you're going to have to help me out with your number. Now I've gotten out of order over here.
What?
Or what's your name?
Javier Cabanillas. I mean, I know who you guys are.
Number 53, Mr. Cabanillas. And who do you know, sir?
I know Mr. Wilkerson and I'm an attorney in Ferguson Law Firm.
Is there anything about that? Thank you for coming. And is there anything about either of those relationships that would make you feel like you couldn't be fair in this case?
No, ma'am.
Thank you, sir. Anyone else on that back row that I missed? Okay, perfect. All right. See, it's not hard. It's not hard questions. So the process this afternoon also, and so let me see if I raise a hand. How many of any of you have been on a jury in here before and had to hear this spiel?
I see one.
I apologize.
2, 3,
I knew I recognized
4,
some names.
5,
There's some faces
Holy
and
cow.
some names. I need to change up my stories, I guess,
spiel.
for you guys that have to listen to it. But it is the same thing. So the process this afternoon can sometimes be a little bit frustrating because the lawyers are not allowed, when they're talking to you, to talk about the specific facts of this case. So they're going to talk to you in hypotheticals and generalities, and may ask you questions that would make you first think, well, I don't know, because I don't know, the facts of the case. They're not doing that just to frustrate you, I promise. That is just the nature of how this works, and they're not allowed to do that. There are no wrong answers. We do not want you to try to answer something in a way that you think we want you to answer. We really need to know how you feel about certain things. That's the whole process. And so please don't try to answer something in a way because you think you might answer wrong. There isn't a right or wrong. It's all about your thoughts on whatever it is that the lawyers are talking about at that time. Let's see. So, well, real quick, Mr. Wilkerson, did you file a election?
It's jury, Your Honor.
Okay, we'll make sure and get that. So in any criminal case, there's two phases in that trial, potentially. The first phase is the guilt innocence phase. And then if there is a finding of guilt, there would be the punishment phase. And the defendant in any given criminal case has the right to choose or elect who punishes him if the jury finds him guilty. In this case, the defendant, Mr. Johnson, has elected that if he is found guilty, it would be the jury who would assess punishment. So that would then become your job if there's a finding of guilt. So we'll talk a little bit more. I'm sure the attorneys will talk a little bit more about that punishment range. I went through that kind of quickly at the beginning, but again, it's between 2 years and up to 10 years. There are times, depending on the trial, where punishment could be enhanced to something worse. There are times that it could be something less. But this offense, the range is 2 to 10. And without any other information, that's where we are on this case at this time. The most important thing about that punishment phase, if we get there, is that the jury can consider the entire punishment range. And the reason there's a range is because every case is different. Every defendant's different. Every set of circumstances and facts surrounding the case are different. And so the legislature gives juries or judges a range. So what they ask, or you have to be able to say as a juror, is that after you hear all the evidence in the guilt innocence phase, if you find the defendant guilty, that you would listen to any additional evidence that was given in the punishment phase and take all of that into consideration, talk to your fellow jurors about it, and consider the entire punishment range from the low end to the high end and get to a number with everybody else in those discussions. That's really all that's required, is that you consider it at this point, because you don't know anything. And so no one can say, would you give 2 years or would you give 10? Because you don't know anything about the case. You just have to be able to consider it once you hear everything. You will have at the end of the trial a written document that's called the court's charge. It's a document that I provide to the jury that has all of the instructions, any legal terminology, definitions. It's kind of your playbook to go by to take the evidence that you hear in trial, put it together with the law that's provided and the instructions in that court's charge, and that's everything you need to come up with your decision. You are specifically instructed not to Google terms or look up anything. You don't need to have any knowledge about anything criminal or legal at all to be a juror, because you'll get everything you need here in the courtroom. I'm going to go through just a few kind of general legal principles that apply in all cases, and then I'm going to turn it over to the attorneys to visit with you. The first legal principle is the presumption of innocence. And our law provides that all persons are presumed innocent and that no one may be convicted of an offense unless each and every element of that offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or provide any evidence at all, because that presumption of evidence is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of his guilt. So if you were to vote right now, whether or not the defendant is guilty or not guilty, what would your vote be? Okay, I think I heard that right. What was it? There we go. Okay. So the law says that the prosecution, or the state, in this case, Mr. Coleman, has the burden of proving the defendant guilty, and he must do that by proving each and every element of that offense beyond a reasonable doubt. And if he does not do that, then you must acquit the defendant. I've used now that term beyond a reasonable doubt a few times. Many years ago, there was actually a definition that was given to jurors as to what that meant. That, however, was abolished some time ago by the Supreme Court, that we are no longer allowed to define for you what beyond a reasonable doubt means. I think that kind of means two things. I think first, you decide for yourself what you think beyond a reasonable doubt is. And then second, you decide if the state has proved each and every element of the offense beyond a reasonable doubt. Now, there are other burdens and levels of proof. If you're in family court, they have one and they're able to define it for you. If you're in civil court, you can get one and they get to define it for you. Here, you don't get that definition, but it is the highest level of proof. And that's really pretty much all we can tell you. It's not 100%, but it's the highest level of proof that we have. Our law also provides that a defendant may choose to testify on his own behalf if he would like. However, that same law, as you all know, which is our Fifth Amendment right, he can elect not to testify. And if he chooses not to testify, you have to not consider that in any way. You cannot consider or discuss why he didn't testify, what he might have said, or anything like that. You can't use it as evidence of guilt against him. A lot.
We're going to fast forward just a teensy bit.
Other burdens and levels of proof. Have a conversation with them so they can get to know.
Okay, here we go. Questions from the
It is
attorneys.
usually the quiet ones that get to come spend a few days with us.
This is
This
is true.
Mostly true, but also just a reason for you guys to kind of open up and talk to the attorneys.
If you don't want to serve,
so Mr. Coleman, you may proceed.
Thank you, Your Honor. Good afternoon, ladies and gentlemen. Again, my name is Tommy Coleman. I'm one of the assistant district attorneys here in Jefferson County. For you folks in the back, if you're having a problem hearing me, just raise your hand, and I'll do my best to speak a little louder, project a little more. I always feel like I'm yelling at these poor people in the first row in my attempts to make sure that you hear me way in the back there. Listen, I know there are other places you'd rather be. I know there are other things you'd rather do. But I know for me at least, and I suspect the same is true for you all, that if you were sitting where this defendant is sitting, you'd want people to show up and give 100% attention to the issues in the case, to the presentations of the attorney or attorneys in this case, and not be thinking about the grocery shopping you can get done, the things on your to-do list you can get done, or the work that's piling up on your desk. So, well, with that being said, I will make you a promise if you make me a promise. I promise I will limit my remarks to you as close to 30 minutes as I can. If you promise me that you will give me your full attention, that you will engage me in a back and forth discussion, and you will truthfully, honestly answer the questions that I ask you as it relates to this case.
Is this like a sub oath you're asking them to take?
I'd ask you to raise your hand and show me that you have agreed. All right, very good. We haven't agreed. Sounds perfect. For the record, looks like just about everybody raised their hand. And for you guys, just so you know, I'm not talking to myself when I say stuff like that. I just want to make sure that it gets on the record. So from time to time, I'll be pointing some things out like that. I've read your jury questionnaires. I know a little bit about each and every one of you. Ms. Bridges, juror number 1, you're a florist, right? Juror number 4, Mr. Van Houten, you're a financial advisor, correct? Sir. Mr. Cruz, juror number 20. United States Postal Service, right? That's right. Juror number 26, Mr. Bob. Yes, sir. All right. HEB.
Heb.
Sergeant Bowman, I know where you work. Yes, sir. Juror number 33, next to Mr. Bowman, you are retired from Valero, right? Correct. And juror number 50, did you carpool here today with anybody?
Yes.
Who did you carpool here with today? Who happens to be sitting right next to you, right? Yes. I've never seen that.
Oh my gosh.
I've never seen that. And I've been doing this for a little while. All right, so we may circle back to that a little, because I would want to know if the two of you, and I can imagine how they would, if the two of you were to end up on the jury together and you happen to disagree, how would that work?
Husband and wife.
After you leave the sport. That's what I'm getting at. But my point is, I know a little bit about each and every one of you, so it's only fair to tell you a little bit about myself. I was born in the state of Texas, lived in the state of Texas all my life, but for the time I was in the United States Army. And After graduating from law school, I have essentially been a prosecutor for my entire career. And from time to time, I serve as a special federal prosecutor. I enjoy being a prosecutor. And contrary to what some people may think, Ms. Logan, you're number 6, being a prosecutor is not always about seeking conviction, not always about sending people to prison. It, by statute, Ms. Ramirez, it is by statute I am required to seek justice. And that's what I want for this defendant. I want justice for this defendant. I want justice for this defendant, and the way we get there is for me to select 12 of you, or for us to select 12 of you, Mr. Juror number 16, Mr. Bristol, 12 of you who will be fair and impartial and listen to the evidence in this case and render a verdict based on that evidence alone. Okay? The last thing I want you to do, like the judge mentioned, Mr. Gerard, number 23, right?
Yes.
You're an electrician, right?
Yes.
Last thing I want you to do is try to give us an answer that you think I want to hear, or Mr. Wilkerson, or even the judge wants to hear. Now's the time to be honest. Ms. Bridges, juror number 1, you're a florist. If I were to ask you what is the prettiest flower out there, even though you know that I am a fan of an orchid of orchids, and I have like I'm the orchid fan club president, chapter president, and you know all that stuff about me. I have a T-shirt that says I love orchids, and I tell you, and I ask you, what is your favorite flower? If you don't think it's an orchid, I want you to tell me. If you think it's a tulip, that's fine. If you think it's a rose, that's fine. Now's the time to tell me
I'm making
what
merch
your
right now.
honest
I love
opinions are.
orchids.
Because once you're selected as a juror,
I love
and
orchids
you are
and
sitting
jury
in that
duty.
jury box, you are obligated to follow the law, Mr. Moen. Okay? Whether or not you like the law or not, you're obligated to follow the law at that point. Okay? Just out of curiosity, Ms. Bridges, how long have you been a florist?
I've been one now for about 2 years.
Sorry. What is your favorite flower? Now that I'll open the door. It's a what?
It's called Protea. It's
I
a
will-
very interesting flower from South Africa.
I will Google it. I will Google it after Protea. Okay. But you see my point. What I'm getting at is now's the time to say it. I mean, and I'll give you another example. People disagree oftentimes. While this is not a drug case, Miss, who have I not talked to? Miss Loomis, 19? Lemus. Oh, it's a good point. If I mispronounce any of your names, please feel free to correct me. But Miss Lemus, juror number 19, oftentimes in these drug cases, we get people in here who say, particularly with the marijuana case, oh, it's a stupid law. It should either be decriminalized or legalized. And again, that's fine if you believe that. It's okay. There won't be a trap door that opens up. You won't get tased by Mr. Savoy over there.
Bummer.
Now's the time to tell us your honest opinions about the law. I think it's a stupid law. It's a stupid law. But for instance, using that marijuana example, once you get on that jury, and if I prove all the elements of my case in that marijuana possession case, and I prove them to you beyond a reasonable doubt, then you're obligated to follow that law, whether or not you like it or not. Does that make sense? Does anybody have any questions about it? Juror number 14, Miss, let me look at that last name. Satcha Tano. Satcha Tano wrote for BISC, right? All right, so does that make sense? You follow me? Give me your opinions now. I'll give you my opinion about something. If the legislature were to meet in the next session and outlaw bacon, make it a felony offense to consume bacon, I may as well turn myself in. I may as well go down to the jail and say, lock me up. I would think that's the stupidest law because I love bacon. I love orchids and I love bacon. So,
man, now I have to.
All right, let me just move on.
I have to change
remember,
my
30
shirt.
minutes.
Look,
so let me move on.
I already had this one designed,
outline
but now I have to add
here.
bacon to it.
While I cannot talk to you about the law or the specific facts in this case, I can say that this defendant is charged with being a unlawfully possessing a firearm while being a felon. And more specifically, that's found in chapter 46.04 of the Texas Penal Code. It states that if a person has been convicted of a felony offense, they cannot possess a firearm until after 5 years after their confinement ends or after their period of parole ends. And even after that, even after the 5 years, you can only possess it at your habitation. I'm looking at you, Mr. Belair, 29. Does that make sense to you? At least, we'll get to whether or not you agree with it or not, but does the statute, as I read it to you, at least make sense? If you're a convicted felon, you are prohibited from possessing a firearm unless or until after 5 years, then you can possess that firearm at your residence, your habitation. What do you think about that, juror number 17? First question, Mr. Lugman, is why do you think the legislature would make that carve-out for after 5 years of possessing it at your residence?
I wouldn't think do it.
Yeah. Somebody help Mr. Lugman out. What anybody?
Protection.
For protection, exactly right. Who said that? Way
So
back in the
5
back,
years
juror number-
unprotected?
Oh, my chart's got it. I got it right here. Bail, 49? All right, yeah, protection. Yeah. Let's get it. We're going to get you on the next question there, Mr. Hawkins. I'm sorry, I was coming to you, Ms. Bill, buzzed in before you. Yeah, presumably that's why they did it. Is, after a certain period of time, 5 years, the legislature in its wisdom says that, yeah, at least for protection, I think that that's the reason. If for protection at your home, your residence, your habitation, you can have a firearm. But you're still prohibited, even after 5 years, from possessing that firearm anywhere else other than your residence. Juror number 9, Ms. Stevenson, worked for Port Arthur ISD. All right. What do you think about that law, Ms. Stevenson? It's fair. I mean, think about it. The legislature, they legislate a lot of behavior in society. In other words, you can't drive 60 miles an hour in a school zone. That's against the law. You can't marry a 13-year-old. That's against the law, Ms. Simeon. Juror number 5.
Juror number 5. Looking at you, juror number 5.
The legislature legislates a lot of behavior. Now, I know there are some Second Amendment folks out there. I just need to find you. I need you to raise your hand. Remember our deal? You give me your honest answers, your honest feedback. Otherwise, I'm just going to talk as long as the judge tells me to sit down. So, all right, there's one of them. Juror number 17. But what about my Second Amendment rights to carry a firearm? You're a felon, and that's the law. Again, you can have your opinion now while you're sitting out there, but once you're in that jury box, and if I prove the elements of this unlawful possession of a firearm by a felon, your opinions, your personal feelings about it, kind of go by the wayside because you're going to take an oath to follow the law. You're making it too easy for me, Mr. Lubman. Somebody out there is saying, you know what? I want to go hunt deer. And I'm a convicted felon. I want to go hunt. I'm not a hunter. I mean, where else do you hunt? But this is Southeast Texas after all. And I want to go hunting. And just because I've been convicted of a felony, I shouldn't pay that high penalty. You had your hand up, juror number 16, Mr. Bristol.
Yes, you had your choice before. And you made your choice, and now there are consequences that must be attached to them.
Thank you, Mr. Rick.
Okay, the shirt.
Anybody else? You guys too easy. Somebody disagree with me.
The shirt has been updated.
Juror number Maribel 24. Maribel, you have the most.
I need a comma after bacon, though, right?
You're the A manager or the manager at Rayos?
Yes.
He was. I couldn't have that job.
Oxford comma.
There's just too much temptation there. But my point is, come on, somebody has to think this is too heavy-handed by the legislature. No?
Yeah, guy in blue. Guy in blue. Guy in blue in the middle. He's trying to raise his hand, then he covered it by combing his hair.
5 years, the habitat of your home, once you leave your home, is your vehicle considered protection?
He wants to argue the law.
My understanding is that it's limited to your residence. And I don't profess to be an expert at the law. Mr. Wilkerson may have a different take on it. And the judge certainly will correct me if I get wrong. But my reading of chapter 46.04 is that after 5 years, it's limited to your residence, your place of residence. My take on the law, my understanding of the law. Anybody else before I move on? All right, way in the back there, Mr. Davis.
If that's for the rest of the life, he can.
Oh, Mr. Davis, let me get your number on the record. 51. Yes, go right ahead.
You would never be able to possess a gun though the rest of your life.
That's current state of the law. That's my understanding of the law.
Hunting rifle of the.
It's my understanding of the law, Mr. Davis. I mean, if you think about it, again, we talked about all the ways that the legislature regulates our life. I mean, there are other penalties that go along with being a convicted felon. For instance, you can't vote. For instance, you can't serve on a jury. You can't be sitting where you're sitting if you're a convicted felon. You can't hold public office as a convicted felon. There are other consequences, real world heavyweight consequences that come along with being a convicted felon. So. I saw another hand back there in the back. Mr.
Blue shirt.
Cabanillas. First injury law, is that what you practice? Yes. Please.
Are you able to tell us what is it that he's been charged with? Just
being an unlawful, being in possession of a firearm as an unlawful person. In other words, let me read straight from me. Unlawful possession of a firearm. And in this case, what makes it unlawful is having been previously convicted of a felony.
And he served his time for that previous conviction of a felony. He served his punishment, or was taking his rights away.
That's the law.
Yeah, that's the law.
I heard somebody else agreeing with you. Hold on a second. Let me
I think that's done.
Okay, thank you, Mr. Cabanillas. See, no trap door, no taste. You're sitting there. Look at him. He's still there. Somebody else was nodding. I heard him up here.
Yes, what comment is that?
Give me your journal, please.
What you said?
Mr. Oliver, go right ahead, sir.
It's okay, not okay to have a weapon, but it's the decisions you make. So if you, before the felon, would have gotten a permit to carry a weapon, any choice, where is the fine line right there? The decision making?
I don't know that having a permit or not having a permit is of any consequence in this instance, because the law does not carve out or make a defense or an exception to the application of this law. If you have a permit or if you don't have a permit, it's not an issue. It's not an issue. All right, anybody else before I move on to my next topic in my outline here? One thing that I just realized, I always look for trends in my jury. Sometimes we have an inordinate amount of nurses, or we have an inordinate amount of educators. On this particular jury, we have 3 people who were born in or grew up in California. Jury number 30, Miss Vicky Bavorin, yes. California. Jury number 40, Barraza, grew up in California, right? And jury number 52, Figueroa, yes, California. I've never seen 3 people from California. Again, I'm always just looking for stuff like that. I remember our agreement. I'm going to get back on task. All right, so that offense is punishable, as the judge mentioned, from anywhere from 2 years in prison up to 10 years in prison. That is the punishment range. And as a juror, you are asked to consider the entire range, okay? I would imagine that juror number 18, Mr. Richard, you could probably envision a situation where the appropriate punishment may be on the lower end of the punishment range, right? Or you can also envision a situation where the appropriate punishment may be on the higher end of the range. For instance, what about if they have prior criminal history?
Thank you, Selena.
It's going to be on the high end. As a person who carries a pistol all the time,
yeah.
I don't have one with me right now.
That's good.
That's believe me, you know, I believe in the protection. Oh, you know, I travel a lot. It's in the mood with me when I go.
Yes, yes.
Yes. I kept it between the mayonnaise and the mustard, and served my time in the Army. And
thanks for your service, by the way. Appreciate that. So, is there anything else or anybody want to add about that punishment range? Each case, as the judge mentioned, is different. Each defendant's situation is different. I just want to make sure that you, as jurors or as a potential juror, can consider the entire punishment range. Is there anybody here, and this is kind of an important question, so I'm going to go row by row. Is there anybody on the first row who could not consider as little as 2 years in prison or as much as 10 years in prison if I was to defend my case? Please raise your hand.
Seen no hands.
For the record, I've seen no hands being raised, but you did make a face there, Miss Stevenson, jury number 9. I'm watching. It's like an auction. If you scratch your nose, I'm all over. What's that about? You don't like that punishment method.
Well, no, it's fine, but something that you said
It's not.
was,
Well, let's not keep it about, let's not make it personal. Just tell me what you're feeling, your thoughts
it
on.
depends on, the range is fine, but if like repeated for the same crime.
Okay.
That's true.
Fair enough. Thank you, Ms. Hicks. Thanks for sharing that. Next row, is there anybody on the second row who could not consider the entire range of punishment as little as 2, as much as 10? Raise your hand. All right. No hands are being raised. Third row, same question. Raise your hand if you can't consider that entire punishment range. I'm not trying to pin you down. I'm not trying to get you to commit to any amount at this point. I'm just asking that whether or not you can consider it in for however long. If you consider it for a minute, 2 minutes. All right, I thought about 2 years. I'm done. Now I'm thinking about something else. Third row, anybody who can't do that. And back on the back row, is there anybody on the back row who cannot consider that full range of punishment? No hands are raised on the third or the fourth row. Beyond a reasonable doubt, I've used that term. The judges use that term. She's told you there is no definition of what beyond a reasonable doubt is. It's whatever that level of proof within you is attained for you to reach that point, at least in my opinion, where you say to yourself, there is no other doubt that's reasonable in this case based on the evidence in this case. The way I like to look at it is, if you know it, if you feel it in your head, in your heart, and in your gut, then I would submit to you that that's enough to get to beyond a reasonable doubt. Mr. Hawkins, juror number 7, what do you think about the notion of beyond a reasonable doubt? What do you think about that? Let me give you something to think about. Let me give you something. Because I don't like putting people on the spot. From time to time, I do a PowerPoint when I'm feeling techie. And then on that PowerPoint, there's like a puzzle, and it's got like some pieces missing. If you remember those old school jigsaw puzzles. And if you got, let's say, 95% of those pieces in that puzzle, you could probably make out what that puzzle is. Wouldn't you agree? Now, you would probably want the other 5% of those pieces to make the full picture. But would you agree with me that maybe with 95% of the pieces, you would know in your head, in your heart, in your gut, what that puzzle represents? That's how I like to look beyond a reasonable. Okay. Again, Mr. Wilkerson may have a spin on it, but that's how I like to look at it. I will tell you what beyond a reasonable doubt is not. Juror number 2, Mr. What's pronounced John. John. Yes. I'll tell you what it's not. Yeah, it is not 100% proof. Okay. The legislature does not require me to convince you or bring you 100% proof that a defendant is guilty of an offense. They just don't do it. I mean, because if you think about it, who have I not called on there? If you think about it, juror number 26, Mr. Bob. Yeah. Okay. If you think about it, what's the only way for you to know something with 100% certainty? Okay. Well, help him out. What's the only way to know? Yeah, you gotta be there. Yeah, saw. Yeah, I've seen it. And so the legislature recognizes that, because if you saw it, then you'd be my witness. If you wouldn't be a potential juror. So the legislature doesn't require me to bring you 3 nuns, the DNA like you see on these TV shows, satellite photos, and all that other business. Just so long as, again, you're gonna get tired of me saying this, I can bring you evidence to the extent that in your head, in your heart, and in your gut, you are convinced. And I don't like that jigsaw puzzle example that I've used. Mr. Blaylock, during 39.
Yes, sir.
You follow me on that?
Yes, sir.
What do you think about that? Would you require 100%? No. Sales with I-Corp. What does I-Corp do?
This machine shop, job shop.
Okay. Very good. So again, this is another one of those important questions. I'm going to go row by row. Anybody on the first row who would require me to prove my case with 100% certainty? 100% proof. Raise your hand. No hands have been raised in the first row. Second row. Anybody who would require 100% certainty? 100% proof. No hands have been raised. Third row, same question. Raise your hands if you need 100% proof. No hands. And finally, in the back, somebody, anybody. Is there someone who would require 100% proof? Can we get there with just what? Head, heart, your gut, and you feel it, then there you go. Now, I'm not saying that there won't be any evidence, okay? I wouldn't be here bringing this case if there wouldn't be any evidence. And I want to talk, Mr. Rogers, Grid or 15, about evidence and the types of evidence. Is testimony evidence? Yes, testimony is evidence, particularly if you believe, especially if you believe. Juror number 5, Ms. Simeon, let me ask you this way. You're leaving the parking lot today after this jury selection, and it's just you, it's late, it's after, well after 5 o'clock, somebody walks up to you, and points the gun at you, takes your purse.
Oh.
There's no video of it, there's no other witnesses. You go to the police and you say, look, I got a good description of this guy. He took my purse at gunpoint. Should the police not take your report just because there are no other witnesses or surveillance video? They should take your report, right? Should the district attorney's office not prosecute the case because there are no surveillance video, there is no DNA, there's not the 3 nuns who saw this thing happen? Should my office not prosecute the case? Should prosecute the case. Should you not get an opportunity to take that stand and testify to a jury of your peers that, let's say they catch the guy, the guy sitting in the courtroom, should they not hear from you that, hey, that's the guy that stole my purse at gunpoint?
No, they should take my statement.
That's my point. You can believe Ms. Simeon or you cannot believe Ms. Simeon, but her testimony is evidence if you find it beyond a reasonable doubt. If you believe her beyond a reasonable doubt. People have been proving these cases for many, many years. So there was a video and all this other technical stuff based on witness testimony alone, just so long as you believe that witness testimony. Jury 35, Ms. Ryer. Mr. Ryer? Where's jury 35? Mr. Ryer. I was looking at Ms. Dale 34. I'm going to come back to you. But could you render a verdict if you believed that witness, who is the only witness in the case, beyond a reasonable doubt? Or would you need more proof than just witness testimony? And make no mistake, I'm not trying to trick you. It's not a trick question. I'm saying that you have to believe beyond a reasonable doubt. But if you don't believe beyond a reasonable doubt, then I'm not asking you to convict. Or I wouldn't ask you to convict for number 13 years prior. Okay? So another form of evidence, circumstantial evidence. Circumstantial evidence, and I've heard this example used, and it's been used many, many years. Jar of cookies in the kitchen. You got a toddler. You say, don't eat the cookies because it's dinner time. It's close. And you leave the kitchen. You come back. Cookies are missing. The toddler is in another room, but the toddler has cookie crumbs on his face. Tan.
He stole that from another judge.
What do you suspect has happened, Miss Vernon, Miss Skinner? What do you think is happening? Yeah, the cookies. It's circumstantial evidence because why? You didn't see him eat it. You don't have video of him eating it, but there's proof in the form of circumstantial evidence. The crumbs, okay, and probably the fact that you know your kid. So testimony, circumstantial evidence. This is all evidence. You don't necessarily have to have those things that this TV shows convince you that you need to have, like DNA and satellite photos and that kind of things. Is there anybody here who would require those types of evidence? Let me ask it this way: is there anybody here who couldn't base their verdict on circumstantial evidence and or witness testimony if you believe either one of them or both of them beyond a reasonable doubt? All right, no hands have been raised. All right, I'm just about to at the end of my outline. 5 minutes, Judge. Thank you, Judge. The defendant's not required to testify, okay? I don't want you to hold that against him. I usually spend a little bit more time on this topic, but I'm running out of time. So for the sake of time, I'm not going to go our way again. I'm just going to ask, don't hold it against him. It's not his job to disprove his guilt. It's my job to prove his guilt. So if he doesn't take a stand, if he doesn't testify, don't hold that against him. Another thing, by virtue or by the nature of this offense, the way it's charged is he would have to have been a felon prior to possessing the firearm if you believe beyond a reasonable doubt. I don't want you to hold the fact that he is a felon or was a felon against him, okay? Don't say that he must be guilty of this because he was already a convicted felon, okay? Again, I would normally spend more time on this, but for the sake of time, I'm not going to drill down on it. But you follow me. Is there anybody here who would say, well, he's already a convicted felon. He must have done this new crime of possessing or unlawfully possessing a firearm. Is there anybody here who would do that? Raise your hand. Record, no hands being raised. I think that's about it. I got just a few more questions.
And if we have time, if you need a few minutes.
Okay, so I'm wrapping it up. Is there anybody here, and if this is too personal of a question, we can ask the judge to allow you to approach out of the hearing of the other jurors and maybe discuss it at the bench. But is there anybody here who has a friend, family member, someone close to you who is a convicted felon and you may think that they have been treated unfairly because of their status as a felon? Again, if this is something that's too personal, then you can just raise your hand and let me know that you got that issue. We can maybe talk to the judge. But let's do this, Mr. Richard. Let me go roll our ones. This is one of those important ones. Is anybody on this first row on this side who knows somebody close to a friend or family member who they haven't been convicted felon, but you feel like they've been treated unfairly, maybe in employment, or maybe not employment opportunities, or denied whatever these rights are that we talked about, the right to vote,
whatever
the right to serve on a jury, hold office. Anybody here on this first row of this side? Hold on a second, Miss. Make it low. All right. Okay. Juror number 5, Miss Simeon. Yes, ma'am.
I've had a cousin, actually 2 cousins that were convicted felons, but I don't say that they were, treated unfair because I wasn't in the courtroom. But I have had a couple cousins that I was raised with that was convicted felons, and I've had one of them that actually was murdered.
Wow. And here's what I'm really getting at is whether or not that experience, the experience with your cousins, would somehow make you not be fair or impartial in this case. In other words, is that something that would color your ability as a juror to just render a verdict based solely on the evidence in this case? Anybody else? First row of this side, juror number 4? 11. How am I that far off? 11, Ms. Ramirez. Yes, ma'am.
I also have known someone that was a convicted felon and has had to serve a long term for doing one. So I don't feel like it would in any way affect my judgment though on anybody else's situation. Yeah.
Okay, good. Thanks for your honesty. I appreciate that. And you've already answered the second part of my question, which is would that affect your ability to be fair and so on? Anybody else on this side, first row? Second row, Mr. Richard, you had your hand up, juror number 18. Yes.
Yeah, I got a cousin convicted felon. I had a brother-in-law who passed away who was convicted felon. So one of them I felt like he was wrong to do by being convicted.
And that's a whole separate issue.
Yeah, that's a separate issue.
Yeah, whether or not the conviction was justified or not, what I'm getting at is the consequences or the penalties associated with it afterwards. Do you have any strong feelings about that as it relates to those folks?
I guess not. He's a hustler piece about it.
All right. Anybody else on the second row? Friend, family member, close, someone close to you. You think they've been unfairly saddled with the felony conviction or the penalties associated with it? Anybody on the third row? Friend, family member, somebody close to you. And it will be to the extent where it's kind of in the back of your mind during this trial. I see a hand. You get a number.
My school number is Ayden Durant.
43. Mr. Durant. Yes.
My father is a felon.
Yes.
And I feel as he has been kind of had a hard time getting a job after that. I feel that kind of might have been a little bit.
we may want to visit with you a little bit. We may want to visit with you at the bench here a little later on. I appreciate your honesty, Mr. Durant. Everybody. Anybody else on that third row? Anybody on that last row? Friend, family member, someone close to you. I'm fairly saddled. To the extent that will affect your ability to be fair and impartial. Juror number 60, Miss. Help me with the pronunciation of your name. Just say. I just want to call you. He was way back there in the back. And you got you stuck in the corner. I mean, I don't know what you did. I just felt compelled to call on you. All right. So, all right. With that being said, does anybody know a Detective Lance Carmouche with the Beaumont Police Department? I know you probably do, Sergeant. Is it Turner Kelly? You work for the Sheriff's Department as well, right? I can understand why you guys how you know him.
Is he old?
I don't know how to answer that.
What'd she say?
Is he old or young? He's not. It's not what I would consider to be young.
I don't think he's not old though. Carmouche is young, huh?
If you think you know him, we'll bring you up to the picture to talk about him. Okay. What about a Daryl Wayne Cooper Sr.? Does that name something maybe? All right. And what about a Imran Kale? He's a local business owner. He also goes by Imran Yanis. You might think of him. All right. Well, I tried to stay as close to 30 minutes as I think I could, ladies and gentlemen. I do believe that you gave me your honest attention and answers.
You went over
during this presentation. And for that, I thank you and I appreciate it. Before I sit down, is there any questions that you think that you can think of that I should have asked that I didn't ask as it relates to the issues in this particular case?
Yeah, we already made up our mind.
I look forward to presenting my case to the 12 of you who are selected. Thanks.
Thank you, Mr. Coleman. Mr. Wilkerson, I think before you get started, ladies and gentlemen, what I'd like to go ahead and do, it never fails. If I get started with the next attorney, somebody's going to need to take a break. And so I'd rather go ahead and take a quick break. That way, Mr. Wilkerson can get straight through his voir dire. Please look at where you're sitting, kind of pay attention to that so that when the bailiffs bring you back in, you can get seated quickly. There are bathrooms at the end of the building this way on the first, second, and third floor. So you can kind of disperse about. And there's also some kind of in between the two buildings if you go down that way on the second floor, this floor. So it's 10 till 3. I'd like to maybe just make this about 10 or 15 minutes at the most and try to get started at 5 after 3, okay? Please don't talk about anything that has to do with the case, the people involved in the case. Don't go look up anything. Just take a quick break and come right back, okay? All right, you're all excused.
Well, we're going to zip forward because we can. Some of y'all are saying...
Yeah, there's a couple more, and those are fine. I'll let y'all keep going. I just didn't want them...
Hang on.
Feel like they've been treated unfairly.
The most and try to get started at 5.
They all leave. And then this happens.
And things, transportation, and things like that. So I would think that he would have the knowledge that the defendant is in custody, which would be a kind of a built-in problem. Do you guys agree?
I would agree.
And so we can let Sergeant Bowman know. Are y'all fine with him going ahead and being released?
Yeah. Yes.
Okay, so we'll release Sergeant Bowman. He's number 32 by agreement. And Deputy Williams, you can let him know when they come back. Sharon?
Yes, ma'am.
I think they each get 10 strikes.
The only other one, let's go off the record for a minute.
Oh, man. Off the record, we'll just zip ahead then and get all the way caught up. Now we get to wait. How y'all doing? Appreciate it. This is Judge Raquel West. We're in Texas. We are watching jury selection. It's funny because although we're not used to doing this unless we're up in Thurston County, Washington, this is something that a lot of times you can observe. Not necessarily jury selection, just because they need the seats, but typically the court process, the entire court process is just open. It's just open to the public, and if you walk into court, you can see. Oh, sorry, they went through the metal detector without the bailiff there. So now they can go through. He's checking to make sure it's on. Then you can come through. Make sure you didn't bring that heat you told us you carried every day. I'm trying to get my my sticker, I love orchids and jury duty, up on the channel. It's not working very well. All products. Magnets. Add a product. Product. Choose file. We'll see if it works. Prosecutor's back. Hey, hide a minute so I can get a clean shot of the courtroom. How about that? Do you want to go back until I can go back so we get a shot without anybody in it. Okay. There you go. You got it? All right. Now we're back. Caught up. All right. Do love this courtroom. I want to put it on the thumbnail. It's a good one. I've got a thumbnail going. I've been listening. So far, we have bacon, orchids, jury duty, 13-year-old brides. Why did he bring that up again? And then immediately after bringing that up, call out a juror by number. Looking at you, Mr. Juror number 4. Yeah, that was something else. You think we could watch this trial until we wait for the next one? I think we might be able to. I'm not sure how long it'll last. Probably just a day based on the charges. I'm not sure if we're going to get into it tonight, even with opening statements. Hopefully we can just get through jury selection here tonight. But, I mean, it's already 4 o'clock, straight up. So, like, as a matter of fact, it just switched to 4 right as I was saying 4 o'clock. So, let's see. Judge said a few days. This would be a good... Maybe they can rent it out for movie night, like on the weekends. You can rent out the courtroom, bring your friends, you all fill up the gallery, set up a little projector there where the lectern is. There's only 3 in Texas. Yeah, but they got a few minutes here. They'll be back. If I say I love orchids and jury duty, can I capitalize jury duty and not orchids, or should they all be lowercase? Fran, I need to go to the post office. It's going to be closed before we're done today. I think they rent that room to Star Trek nerds to shoot fan films. Oh, man, that would be great. Well, you were right about one thing. The negotiations were short. Yeah, I can see that happening in there. Dun, dun, dun. I don't want to get a copyright strike, so I can't do the whole Emperor walks in. All lowercase. This is Kimmy Sue. All lowercase. But jury duty, that's our thing. And so I'll have to change it. Jurors are coming back in. I like how they're all dressed for court appropriately. And I do say that. I mean that. Jurors should be able to wear whatever the flip they want. And I don't think it's disrespectful. They're the ones ripped out of their daily lives. Oh, she's got a Captain America shield. That's just awesome. Oh, it's him. Never mind. Him. He's got a Captain America shield. It might be a backpack. It's a backpack. All right. Everyone's coming in, having a seat. Okay. Hang on. good jury pool. I think it's quite nice. I like that everybody showed up. Defense is going to go next. Puts on his jacket. He's wearing all black. A couple more take their seats, and we'll be ready for the judge to come in as soon as the prosecutor shows up. Oh, great. Yeah, you have to be in the original seats, the original order. There we go. I think we've got everybody, Judge. Who are we missing? One guy? There he is. Blue shirt. I like blue shirts. I'm partial. I think we're wearing the same shirt, actually. Looks the same color. Ouch. This mic got in the way again. Okay, Judge, they're back at 4:04. So we're ready when you are. All right, now we just need the judge.
All right, Mr. Wilkerson, you may proceed.
Thank you. Good afternoon. So this is the first opportunity I'm going to have to talk to y'all, and probably the only definitely the only opportunity I'm going to have to talk to most of them. This is the process, as you've been advised, whereby we go through and we try and get to know a little bit about jurors. So let me first echo the sentiments of the court for being here. When the state's attorney said justice for the defendant, justice is a process. It is not an ultimate outcome, right? And that process of justice cannot be done without people such as yourselves showing up, being here, so that we can pick a jury, so that a person can have their day in court, right? Force the state to prove their case, confront witnesses against it. And so, as you know, as you were told, we've had problems lately, sometimes filling all these chairs, which I don't anticipate being a problem here today at all. But sometimes with certain kinds of cases, it can make having a jury difficult because of things that trigger people, right? So thank you for being here. You were asked about whether you or anyone close to you has ever been convicted of felony. Obviously you haven't, or you wouldn't be sitting here. Anybody in here ever been accused or investigated for the commission of a criminal offense? First row.
Hold on, Mr. Wilkerson. I think we might have been missing one.
Someone was trying to sneak out.
You think that's good? You got him?
Yes, ma'am.
Okay. Yeah, you can pull that up however you want to. Go ahead.
Sorry about that. Couple things about me real quick, switching subjects. So, it's getting hotter outside, even in the wintertime. If I walk from my car to the door of this courthouse, especially pulling or carrying my bags, I break out in sweat. And it takes 20, 30 minutes for me to stop. So if you see me and I'm dripping wet, it's not abnormal. So just ignore. And I also have COPD. So if I'm talking to you and I have to stop for a moment, catch my breath, that also is not abnormal. So just bear with me if that happens. All right. So back to what I was asking. Before we stop briefly, I had asked, have any of you been accused of committing a criminal offense or investigated in conjunction with a criminal offense? Going down the first row, anybody ever been accused of committing a crime other than trafficking? Yes, ma'am. What's your number again? You are Miss Stevenson?
Yeah.
Yep. Okay. So you get your number 9. What was it? You who was accused of committing an offense?
No, it was me and my husband.
You and your husband. What was that investigation?
Oh, it was like unlawful neglect of a child, weapon, something like that.
A loss of a child.
What child neglect, basically?
Oh.
Everything was leaving a weapon in the house with a child. Not really locking the face.
Failure to lock up a weapon in a house
criminal
with a child.
investigation or a family case, like just CPS investigation?
Drop down the
Family. Okay. So did y'all go through proceedings in family court about that?
I mean, we didn't have to go to family court.
Didn't even have to go? But best outcome. Best outcome. I was gonna take on you later about burdens of proof if you had been through family courts. Thank you for being willing to share that, though. By the way, just as you've been told before, if a question is too personal, you don't want to share it in front of everybody else, that's fine. Just let us know so we can talk to you individually after the brief kind of is sent out. So down toward the end of the first row, anybody accused of or investigated for committing an offense? No. Second row, anybody?
I'm thinking I might have been, but I'm not really quite sure. It turns out that the neighbor that lived like 3 doors down, she was selling more than vacuum cleaners, and somebody asked her, and
more than vacuum cleaners.
They took us down to the police station, and I gave a statement, and then 3 months later they brought me in, and I had to make another statement, and they told me that my statements didn't match, and my wife at the time said that he can't remember what he had for breakfast, so they.
I'm right there with you.
Did you recently buy a vacuum cleaner?
I don't know if that was really an investigation or whatnot. Obviously,
I appreciate it. You were already married. Because you said your wife said that. Yes. Yeah. Okay. All right. Anybody else on the second row investigated or accused of committing a criminal offense? Going once, going twice. Anybody on the third row investigated or accused of committing a criminal offense? Third row, yes, ma'am. Miss Blow. No. I'm sorry.
Peraza.
Peraza. What were you accused of?
It was at first it was a felony, but they dropped it down to misdemeanor.
Okay. Was it prosecuted? Did you have to go to court?
Yes.
Did you do some type of probation on it or, yes. Okay. When was that?
Over a decade ago.
Decade ago? Do you recall, did you do something called deferred adjudication? Or do you not remember? Decade's a long time.
Yeah,
so.
Well, I got probation for it.
Yeah. What was the underlying allegation?
Steal.
Sounds like a theft.
Thank you for being willing to share that. All right. Anybody else on the third row? Anybody else on the third row? And last break from left to right, or y'all right to left. Anybody accused of a crime or investigated in association with a criminal offense? Yes, ma'am. Miss Grant? Is it? No. Miss Smith, correct? What was your situation?
Assault and battery.
Having been the victim or the aggressor? Alleged aggressor. What happened with that?
Found not guilty. So that
Found not guilty.
Hey, how long ago was that? Anything about that might affect your ability to be a fair and impartial juror? No. Same question to you, Ms. Barras. Anything about your experience might affect your ability to be fair and impartial juror? No. And I think it was Miss Stevenson. Anything about your prior experience affect your ability
I need
to be
more
fair
to
and
go on,
impartial juror?
Greeners, than just...
Something else about y'all. There are, I think, 15 of you who either are in law enforcement or have family members of law enforcement. And so rather than ask each of you who have that characteristic and picking on all of you individually, I'm going to ask just kind of generically, is there on the first row, for those of you who have either been in law enforcement, whether correctional officer or patrol or other investigators for a federal or state agency, or have a family member who is, anything about that relationship that might impact your service as a juror, could be good or bad. Is that going to create anything about that relationship, going to create any kind of bias toward an officer's testimony or detective's testimony? Or can everybody agree on the first row that a witness steps in, no matter who they are, with the same level of credibility, and as they testify, their credibility is the same? All right. Second row. For those of you, I think there's 4 or 5 of you on the second row. For those of you on the second row who have that characteristic that either yourself have been involved in law enforcement or have a family member who is involved in law enforcement, anything about those experiences or relationships that might affect your ability to be a fair and impartial juror? Nope.
Sure.
And no. Third row, same question. For those of you who have been in law enforcement or have served in law enforcement of some type themselves, anybody have any problems being fair and impartial based on that? And then let's see, 50 and 51. It's the first for me too, husband and wife being sitting next to each other. Both of y'all have a son who's in law enforcement, correct? Right. No. Anything about that? Anything about that might interfere with your ability to be fair and impartial? No. Got it. All right. Thank you. All right. You heard an often used allegory mentioned by the state's attorney during during his voir dire presentation, and it was that of a jigsaw puzzle. And so, because of the nature of the case and because of the evidence being presented, I didn't really feel it necessary to do a big slideshow for y'all. So instead, I'm going to ask you to just envision something in your mind, right? And I want you to envision a jigsaw puzzle that is a picture of a firearm. But imagine at the end of that firearm, that piece, that one piece from the puzzle is the only piece missing, right? And then you put that piece down and all of a sudden it's got an orange tip, despite otherwise looking completely realistic. Does that one puzzle piece change the nature of the object that you see? On one hand, you are looking at a photo of a realistic looking firearm, right? But on the other, as soon as that piece is added, you're dealing with an airsoft gun or maybe a paintball gun. So one puzzle piece, ladies and gentlemen, and that's just an example designed to show you and tell you, you know, just one small piece of puzzle can change everything. And you're not always going to know. Well, obviously, if those pieces are missing, there are reasons that they're missing. So just keep an open mind. We aren't, you know, we can't define for you beyond reasonable doubt, but what I can tell you is that it is the highest burden of proof. I was going to pick on you again, but you didn't even go to family court in your situation. So anybody want to tell me what level or burden of proof they think the state has to reach to terminate your relationship with your kid for some sort of, well, all they really have to find is that it's in that kid's best interest. Anybody want to take a stab at it? Burden of
I
proof?
have a question on that.
Yes, ma'am.
Airsoft gun, if that is gonna be up for discussion, I would need proof that it's not an airsoft gun.
So, and just for clarification, the examples that we use during voir dire aren't necessarily related to the case, but I will tell you that a firearm is legally defined, and a firearm requires that it be capable of projecting a bullet by combustion, right?
Needs to have a
And
gunpowder charge.
The definition will be in the charge. Like he's saying, yeah.
But you would want proof that whatever is seen is actually a firearm as defined by the law?
Correct.
Anybody else feel the same way? Yes, sir. You're number 4, you feel the same way? You're number 2? Yes, ma'am.
The same way.
I'm sorry, I already talked to 40. Yes, ma'am. Somebody back here on the 3rd row, raise your hand. What's your name now?
36.
36, you feel the same way? And then somebody on the very last row. Yes, sir. What's your name, sir?
James Garner, 57.
Mr. Garner, thank you.
Yeah, I'm aware that there are some, that it's important to define the firearm, that it's actually a firearm.
All right, thank you. Thank you all for those comments. And
agree with that as well.
What's your number, ma'am?
Everyone's raising their hands. They're all getting struck.
Y'all can tell me faster than I can look it up. I'm sorry. No matter how plainly I even type the names in, by the end of the day, this is what y'all's charts look like. And as you can see, my handwriting is not the prettiest in the world. So it gets a little crazy when I'm trying to who's who and counting chairs real quick to try and figure it out. So I do apologize, but thank you. And thank you for volunteering that. Circling back on getting back to burdens of proof, and again, the state is required to prove every element of the offense, right? That a firearm is indeed a firearm is one of those elements that the state's required to prove. And so, you know, they have to prove that beyond a reasonable doubt. And the reason I was asking about terminating a parent and a child's relationship is because that standard for all of those of you who have never been accused of a crime or have been investigated in relation to a criminal offense, a vast number of you, the majority by far, have children, whether those children are still young or are 30, 40, 50 years old now. And so I ask you, when you're talking about what the state has to prove, and when holding them to the burden, that highest level of what they have to prove, ask yourself, if the state of Texas wanted to sever my relationship with my child, what level of proofs would I want them to have to be held to? Right? That's clear and convincing evidence. That's not even beyond a reasonable doubt, right? It's a step down. So when you're thinking about burdens of proof, when you're thinking about those things, if you've never been accused of a crime or you don't have a family member who's been convicted of an offense, then oftentimes these terms, they are very abstract, right? And while we see them on TV shows, we don't go around talking about, I believe beyond a reasonable doubt my son stole the cookie out of the cookie jar. We just don't talk like that, right? And so when you come in to be selected, when you come in and you serve jury duties and you're talking about the case and talking about the evidence and talking about these legal ideas, these legal requirements, right? Try the best way to understand them is to be able to somehow relate them to your own personal experience. And I would venture to guess that none of you have had your relationship with your children terminated by the state either. But those of you who do have kids, I imagine have some kind of feeling about if they wanted to do that, what level or what evidence would you want them to be required to present in order to do it? Obviously, people's relationships with their children are sacred, right? And so that's why I often point to that example. We talked about a missing puzzle piece. Anybody ever looked at those? Y'all know what fractal art is? Anybody know what fractals are? I see a couple of heads nodding. Let me go back to the third row, ma'am. Sir.
Freckles? Is that the electrical wood art?
Mr. Reinhardt, 35. You seen fractal art before?
Yes.
And so can you, and Miss Dale, you've seen it before as well, correct? Can one of you explain for everybody what fractal art is?
Well, it's taking apart items and reflective, and it infinitely goes into a direction. Whereas, basically it says it keeps on going and going and going. It takes parts of it, look at that plot, it keeps on going. It just repeats.
And those
never mind. I don't know what it is.
Art pieces
is he drinking
that
Heineken's?
Are often created by use of mathematical equations. They also, for some people, show 3D images, right? Not everybody can see it though. You have to really relax your eyes and kind of stare off into the distance. Anybody else remember doing that? Maybe staring at a poster, see a couple heads nodding, a couple hands coming up, right? So by some token, anybody ever look at those drawings or photographs that say, what do you see? Right? Anybody? Yeah. Especially if you're on social media, you've probably seen those before, right? Where somebody's like, hey, what do you see in this picture? And so when I put video presentation up, I show you an image like that where people can see different things. And the sole purpose of that is to remind everyone that two people can look at the exact same image from two entirely different perspectives, right? And that's why a verdict requires all of you rather than just a few, because you all come from different perspectives, right? You all see things based on your own experiences. And so I just want everybody, if you are selected to serve on this jury, to remember as you go into this case that just because one person or one witness tells you something is the way they perceive it, does not necessarily mean that's how you should perceive it. Oftentimes, all over our life, talk about media, for instance. Most media today is commentary rather than straight news, right? Whatever side of the aisle you're on, whatever channels you watch, it is not as much factual as it is telling you how they feel about it, kind of what you should feel about it, right? When a witness testifies, they're testifying as to their observation of facts. Just because the way they perceive the fact is one way, doesn't mean that there aren't other possibilities. And I just want each of you to be able to keep that in mind going into this process. All right, so, and then circling back, I had some questions, for some of you. That y'all fill out these questionnaires, right, when you are contacted and asked to serve on jury duty, especially with the IJUR system, you fill them out and, by the way, Mr. Bishop, pick on you for just a minute. Thank you for writing. You wrote probably more than I've ever seen in a juror questionnaire. But no, I mean, I kid about it, right? And some of you giggle, but these little questionnaires and these 30 minutes that we get with y'all don't give us an opportunity to really get to know you and what your life consists of on a day-to-day basis. And whether you recognize it or not, those patterns in your life on a day-to-day basis, what you've seen and what you've experienced, all impact how you form your decisions, how you make your decisions, and what you see, how you see it, right? So, in trying to learn a little bit about health, that's why we try and do it in different ways: hobbies, right? Interests, family dynamics. Miss Timmy, your husband's retired. Where did he retire from?
Or Meyer.
I'm sorry?
Meyer. It was he was a truck driver.
Truck driver? Okay. All right. Thank you very much. Mr. Walker, number 25. Mr. Walker. Yep. Thank you. You're a teacher. What grade do you teach?
Right now, middle school.
Middle school. Have you which district do you teach in?
Beaumont.
Beaumont ISD. Do you have and I know pretty crazy, or it seems like every day, but do you have students? Obviously, your students aren't charged. With felonies because they are juveniles. But do you have?
Why are his students charged at all?
Students who get in, I guess, commit unruly acts or maybe get in fights or whatnot, things that if they were adults might result in criminal charges. Yeah. And
they're supposed to be asking questions. Instead, these two guys just talk the whole time.
When you're getting to know those kids, you spend in middle school, you still spend what, a semester, or y'all in trimesters?
It's 9 weeks or a semester.
9 weeks a semester. So you spend 9 weeks with these kids, basically, right?
Now, whole year.
Whole year? Okay. And so is it fair to make a determination about a kid during the first week, or have you, let me ask it to you this way. Have you made a determination or started to feel like you understood a child, and then later on, maybe weeks later, maybe months later, learned something new or saw some change that made you rethink those assumptions and beliefs regarding that child?
Not necessarily. The child changes, something happens in their environment.
Children grow, people grow, though, correct? So everybody, we're always learning. Everything we interact with becomes part of our life experience, right? No matter how short, how brief, or how meaningful and deep that interaction is. We're all growing and changing every day. Oh, let's see. I think next to Mr. Walker, Mr. Allen, you,
Yes, sir.
your spouse. Oh wait, you're not married. Never mind. You skip over you. Sorry. Mr. Oliver. Olivier, is it Olivier or
Oliver over here texted Olivier that.
Gotcha. All right. Both you and your wife are retired, right? Right. Where'd y'all retire from?
My wife retired from was Time Warner Cable.
Okay.
25 years as manager. I retired last pretty job construction with Grand Safeway.
Okay.
Prior to that, I was a manager at Walmart, Lowe's, Americo, Central, Synthetic Rubber Company.
Gotcha.
And Texaco back in the day, 80s.
Brand, is that Brand Corporation?
Safeway Corporation.
Safeway, did I?
Kathleen, I drove, heavy duty machinery, forklifts.
Construction.
Construction.
Place, okay. So you've done a lot of different things from retail to construction and whatnot over the course of your life, okay? And you said that, I'm sorry, you said that your wife was a manager at Time Warner?
Yeah, it's cable company back then, spec for the other.
Was she customer service or lineman or customer service? All right, thank you. Let's see.
These
You're
questions
number
are so useless.
33. What? Well, first of all, you have a brother in law enforcement, right? Are y'all close?
Bolton?
Yes, Moten. 33?
Yeah. I have a brother.
You have a brother in law enforcement. Are y'all close?
Yes.
Do y'all talk about
He had fallen asleep, I think.
him being out on, I can't remember what type of officer you said that he was.
He was a jailer and a transport.
Jailer. So do y'all talk about,
He talks a lot.
it talks a lot, does it talk about the people that he deals with in the facility?
Yes.
I just noticed this attorney, in addition to his 3 cans of
But
I don't know,
in
Heineken,
terms of hearing all of that talk,
also brought a
nothing
personal
about that's
fan.
gonna change how you perceive witnesses in this case, one way or another.
No, I just listen to what he got to say.
Let him talk. Is your wife is retired, correct?
Respiratory therapist.
Respiratory therapy, okay, thank you.
Mr. Wilkerson, you have about 5 minutes.
Okay, thank you, I missed one. Let's see. I know married couple in the back are landlords. Miss Figueroa, you are also a teacher of what grade?
He says he sweats a lot and has COPD, but I've never seen one bring a fan before.
I'm sorry?
Pre-K through 5th grade.
Okay. You got them real young, huh? What district?
Port Arthur.
Port Arthur. Well, all of you teachers, thanks for everything you do. Because things really are getting crazy. Jurors number 38 and 41. I want to pick on y'all for just a second. I'm running out of time. Both of you, though, and a couple others, I believe, but both of you, let me see, Mr. Billy, is that correct? Miss Billy. Okay, thank you. And Mr. Ward, correct? Okay. Both of y'all had served on criminal jury trials that went to verdict before, correct? What trial, Ms. Bilia, what was your trial?
Well, I've been on 3, but the most recent one was, Judge Stevens, with Samantha, the police officer. Can't think of her name.
How long ago?
It's been a year and a half, 2 years ago. Did I say? I'm not sure. I just, without just saying it, she was killed by a drunk driver.
Right.
But I cannot think of Samantha's first name.
I understand. Yes, ma'am. I know what case you're talking about. I don't remember her name.
I remember the names, don't remember his name, but yes, I served on that.
Yep. Okay. And your other 2, did they also go to verdict?
Yes.
Were they also felonies or?
One was a felony, yes.
All right. Were all of your verdicts guilty verdicts?
Yes.
Okay. And then, Mr. Ward, how many criminal trials have you served on? Criminal juries, I'm sorry.
2.
2? How long ago?
Very historical. It's been in plus 15 years ago.
Okay.
Now I speak for a jury. This court last September, 85.
Okay. Beginning of trial, do you recall who the defendant was?
No.
None. What happened to that trial? Did it go to verdict or?
Whoever's phone that is, can y'all make sure and turn your phone off, please? That's okay.
It's blue shirt guy.
Was there a plea or something like that happened? So the defendant changed their plea before trial actually got going? Okay. Both of your jury service, both of your times on jury service for criminal trials went to verdict. Well, I'm sorry, only the first one went to verdict. And was that a guilty verdict? Okay. All right. Y'all, thanks for bearing with me. Thanks for playing along, responding, even if it was head nods. It'd be some of your way from paying attention. Thanks for being here, truly.
Thank you, Mr. Wilkerson. And so, ladies and gentlemen, what I'm going to do now is ask. I've got a list that I've been compiling with the attorneys, probably of just a few of you that we need to come back in and visit with about some questions. Is there anyone who, now not because of work, so I have to be careful how I ask this question, because I can't excuse you for work related reasons. But if something came up from the time that you signed up for jury duty and now medically, if you have some procedure that would make it where you could not be here for the next 3 or 4 days, is there anyone who has any issues like that for just the next few days this week? Yes, sir. And what is your number in the back? And is that something you want to share privately, or do you want to talk about what's
Really proud of my mom tomorrow.
your mom has an appointment tomorrow? Is there no one else that can take her to that appointment? What time is that appointment tomorrow? Okay. Anyone else with anything like that? Hold on. I'm sorry. And you are, is it number 12, Mr. Moman?
Yes.
And what time is your appointment?
1 o'clock.
And where is it?
Houston.
In Houston? It's not something that can be changed?
No.
Anyone else? So what I'm going to do, if I can ask if everyone just be real quiet for just a minute, I'm going to have the lawyers come up so we can make sure our lists are the same. And then I'll let you all know who we need to visit with. Mr. Coleman and Mr.
I'm not sure if I can be real quiet for this time, Judge. If you'll allow me a pass, that would be great. Ms. Ari is trying to get me to find a glass repair shop. And I found one at one point, but now I can't find them again. So let's see. Boat Harbors, Dollar General. That's not a glass repair place. I give up. Can't find them. It's a door. It's our door that got shot out. We're finally trying to replace it. So, yeah, if you haven't heard that story, it happened a long time ago. We just have left it. We've left it be a hole. So it's like a screen door, but there's no screen. Maybe we should just put a screen there instead. Just instead of have glass in there. If you're driving to Houston, that's not an appointment you can move easily. No, not. It's a bit of a drive. Everything in Texas is a bit of a drive. What city? Beaumont. Where in Texas? I don't recall off the top of my head. Is it Beaumont? So what you're saying is the windshield wouldn't work. It could. It would just look funny on the front door. All right, let's see if they figured it out. Who has to come back in? We might be muted here for this part. Judge, if you could let us back in, that would be great. I'm watching the court stenographer's hands, and they are moving, which means people are talking. Looks like the defense lawyer's talking. There's no way they picked the jury already. Beaumont, Jefferson County, Texas. People are grabbing their stuff, so it looks like people are headed out. But not all of them. A few of them might have been asked to stay. I wish I knew what they were going to do tonight. Tell you what. If she kills her feed, then well, she's done. You drove through Beaumont and did not stop? I think I successfully created a magnet. 2x3. Let's order them. I've got a proof. Acrylic magnet. Thought this was Wisconsin, and then we moved. We were in Ohio this morning. OG Boy Mama X3, member for 21 months makes you an OG. You are an OG. 21 is OG. Let's see, haven't been in much. Been following the Guthrie case closely, but I missed my RFM. Oh, man, that's a tough one. We're still stuck here in limbo land. Not stopping in Beaumont is a good plan. I've had a few jobs in Lamar U, and I make sure I don't have to get gas while I'm there. Is it that bad? We've been great. We've missed you, though. Welcome back. Had a great case this morning. It was wild out of Ohio. Just a quick one, but it was pretty good. Let me see if I can resize this one. No, that's the wrong one. All right, we'll work on that later. What do you think? I think we're done. I think Judge West has kicked us out of her courtroom. I think we'll see if we can follow along. I'll tell you what I'll do. I'll set up the recorder to watch her just to make sure nothing happens while we're away. And let me do it this way. Hold, please. Give me camera 3. Nope, give me 2. Don't need Warren County anymore. Let's go to 2. I think we'll just leave it. We'll just leave it and watch and see what happens. So. All right. Let's see. 4:47. I think it's time to call it a day. Is anybody still here with us? Let's do a quick check here. Not a full-on roll call, but it looks like a few of you might be here still. Had a fun day. It was amazing morning. So if you missed that, do go back and watch that. It was well worth it. Ohio was interesting. The outcome was not what I expected for sure.
In front of the Walmart.
But it had everything else that we expect. 420 people here. It's time to let you guys go. Can't have that number hanging around, right? All right. One more hour of work, says Curly Q. I'm out for the day. Got a grandkid on the phone. We'll see you, Red Pen. Thank you so much. I'll check out the thumbnail. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better, and please stay safe till we go live again tomorrow morning, whenever this trial picks up. We have another trial coming up in Ohio. It's don't tell me. Caleb Flynn. Yes, got it before anyone typed it. Just nobody had typed it yet. But when that one comes up, we're going to jump to that. We'll be following some smaller courts in the meantime. So tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe till we go live again tomorrow morning when this one starts. We'll see you then, maybe a little bit earlier as well. Ohio doesn't let us down. Tumwater didn't let us down. It's been a good day. You guys have a fabulous day. Be good to each other. Have some great food. Search door glass replacement. I will. Thank you. I will check that right now. I'll find that store from Mrs. R.A. Somewhere I've got a quote from them. I can probably look it up on my email. You guys have a great night. We'll see you.